Thank you, Dr. Rennick. Yes, I would like to make a brief opening statement if I could. Good morning, everyone, and thank you, Dr. Rennick, for the opportunity to participate in this important review of the components of Australia's counter-terrorism laws. I would like to acknowledge the importance of the work of the Office of the Independent National Security Legislation Monitor in ensuring the relevance, effectiveness, and proportionality of legislation relating to counter-terrorism matters. Your work is essential to maintaining public confidence in existing legislation, informing discussion concerning any amendments or new proposals, and is a critical element of the accountability and oversight framework under which my organization, the Australian Security Intelligence Organization, operates. If I could provide a few remarks on the security environment, and I would offer that the comments early in your summary, where you contextualize and summarize the environment, are indeed accurate and reflect ASIO's assessment of the environment and the trends in respect of terrorism as outlined. The challenges we face today have been decades in the making. The terrorist threat is both persistent and resilient, and there's very unlikely to be any comprehensive resolution in the next several years. The principal terrorist threat continues to emanate from two violent Sunni Islamist extremist groups, Al-Qaeda and the Islamic State of Iraq and the Levant, ISIL. Both groups have an international following and global reach. Of the two, ISIL has been the most dangerous in recent years. While Al-Qaeda has been quietly rebuilding itself after years of counterterrorism pressure, ISIL has inspired extremists projecting influence globally, including directing attacks in Australia. Since the general terrorism threat level was elevated in September 2014, there have been 6 attacks and 14 major CT disruption operations targeting people in Australia. We continue to investigate a significant number of individuals in relation to their support for terrorist groups. And since the outbreak of conflict in Syria and Iraq and the rise of ISIL, around 220 Australians have traveled to join terrorist groups there, with the majority being males under 30 years old. Around 110 are assessed to still be in the region. Similarly, around 240 passports or passport applications have been cancelled or refused, respectively, with over half of these for cases onshore to prevent travel. Around 80 to 90 individuals have died as a result of their involvement in the conflict, and about 40 have returned. Most of these returned at the early stages of the conflict, and a small number of those individuals remain of ongoing security concern. Since 2014, ASIO has seen an increase of young people and children in investigations. In particular, in the 2014 to 2015 period, we saw a considerable increase in the number of young people and children coming to our attention. Noting every case is unique, this increased involvement of young people was in part driven by a number of broad environmental influences, including the declaration and appeal of ISIL's caliphate, as well as its propaganda campaign with its highly effective use of social media. ASIO has identified in some cases younger individuals radicalizing and escalating to violence relatively rapidly. The participation of young people appears to have peaked, and more recently we have seen a slight reduction in the number of young people requiring our attention. But despite a tempering in terms of numbers, it's important to note that the threat is persistent. Extremist propaganda continues to be accessible online. We know terrorist groups are resilient, and a small minority in our community continues to adhere to Islamist extremist ideology. These factors can couple with vulnerabilities that can sometimes be present in young people and render some young people susceptible to radicalizing influences. Accordingly, ASIO anticipates more young people will come to our attention. ASIO is aware of Australian children in the Syria and Iraq conflict zone. Australian children in Syria and Iraq are likely to have been exposed to Islamist extremist ideology through the influence of family, religious classes, school, military-type training, and displays of violence. Experience and impact varies from case to case, dependent on age, gender, location, time spent in the conflict zone and affiliated Islamist extremist group, exposure to Islamist extremist groups, and inherent violence in the conflict zone. Now, while violent Islamist extremism has been the most significant driver of the threat environment, as you mentioned in your opening remarks, right-wing extremism is also an area that we're focused on. Since 2014, Australia has seen a rise in new right-wing ideology, primarily reflected in large-scale protest activity. And while most of these protest activities have been peaceful, some have resulted in small-scale violence when protesters and counter-protesters have converged. Extreme right-wing groups and online forums present an attractive ideology for violence-prone individuals. Similar to radicalizing factors in Islamist extremism, young people may be attracted to the type of ideology, messages, and methods espoused and used by newer extreme right-wing groups. Like all radicalization, it is plausible that individuals will be exposed and gravitate toward right-wing ideology whilst children. In summary, ASIO assesses that we are at a point where the challenge of global terrorism can be characterized as a multi-generational one. For this reason, it's critical that we calibrate our collective efforts for the reality that young people, including children, are being exposed to extremism, and this will continue, albeit perhaps in fewer numbers than seen in recent years. Australia's legislative settings need to be appropriately tuned to manage this challenge. Thank you for the opportunity to offer some opening remarks.
I think what we'll do is we'll have each of the opening statements now, if that's convenient, before we go to questions. So, Ms. Chidgey, would you like to go next? Or Mr. Sheen, I don't mind.
Thank you, Dr. Rennick, for the opportunity to appear at this hearing. It may be useful if I briefly outline the decision-making environment in which the Minister for Home Affairs and the Attorney-General operate. The Minister for Home Affairs has responsibility for efforts to counter terrorism and national security and law enforcement policy more generally, and obviously many other things. The Attorney-General has policy and administrative responsibility for prosecution and sentencing frameworks. This includes responsibility for legislative provisions in the Crimes Act concerning bail, sentencing, imprisonment and release on parole of federal offenders. The Department of Home Affairs and the Attorney-General's Department work together to develop policies and legislative proposals that necessarily impact in these spaces. In the context of the subject matter of your current inquiry, the Attorney-General would have the lead in advancing any policy and legislative proposals. This will be done in close consultation with the Minister for Home Affairs and mirrors the collaborative working relationship fostered between the respective departments. The Department of Home Affairs, established in December 2017, has been shaped by two guiding principles. As our Secretary has recently said, we're focused on building a team which respects deep subject matter expertise while embracing opportunities to collaborate across government. We also seek to build productive relationships outside government, working cohesively and comprehensively with industry, academia and the community. The Department is founded on a deep respect for the rule of law. We don't seek security for its own sake, but because it underpins economic prosperity, social cohesion and an open society. The Department of Home Affairs works to prevent terrorism through the Countering Violent Extremism Centre and administers the Commonwealth's post-sentence preventative detention scheme for high-risk terrorist offenders, among other things. Our counter-terrorism efforts also extend beyond our borders as we work with international partners to ensure our region is equipped to respond to terrorism. As the Commonwealth Counter-Terrorism Coordinator, I coordinate Australia's counter-terrorism arrangements for the Prime Minister and for the Minister for Home Affairs. And I lead whole-of-government coordination through the Australian-New Zealand Counter-Terrorism Committee, or I should say whole-of-government's coordination through the Australian-New Zealand Counter-Terrorism Committee, which provides expert, strategic and policy advice to heads of government and other relevant ministers and coordinates an effective nationwide national capability. As you've heard already from the Acting Director General of ASIO, the threat environment continues to be complex and constantly evolving. Terrorists and violent extremists are becoming increasingly ruthless, adaptive and creative. Despite suffering defeats on the battlefield, ISIL continues to radicalise individuals and remains a very real threat. Individuals are being radicalised online and are teaching themselves to carry out violent attacks with minimal support other than online encouragement. Younger Australians can be susceptible to these terrorist ideologies. The Australian Government has established early intervention arrangements across Australia to assist people at risk of radicalisation to disengage from violent ideology and reconnect with their families and broader community. This emphasis on building a cohesive, resilient community aligns with other legislative and law enforcement responses to terrorism. Duncan Lewis, Director General of Security, has said publicly we are not in a position to arrest our way to success. He recognised that the secret to resolving this problem lies in the issue of community cohesion and countering violent extremism. Home Affairs has three key objectives within this early prevention and intervention work. One, to build the resilience of communities to counter violent extremism. Two, to support the diversion of individuals at risk of becoming extremists. And three, rehabilitate and reintegrate violent extremists. State and territory corrections and juvenile justice agencies are responsible for the management and rehabilitation of offenders currently in custody and on parole. However, Home Affairs supports these agencies by ensuring a comprehensive national approach to addressing violent extremism in the correctional system. This includes training for corrections staff to recognise signs of radicalisation and supporting rehabilitation programs for terrorist offenders. And of course, my colleague from Home Affairs, Sam Grunhardt, is with us here today from that part of the department. I appreciate you, Dr. Rennick, are concerned with inconsistencies between state and territories' treatment of child offenders. In principle, the department supports efforts to establish a consistent approach towards the treatment of terrorist offenders, irrespective of their age. However, the department also recognises that a core feature of Australia's federal system of government is that states and territories are responsible for matters of criminal law. Concerns about differences in state and territory approaches should not be taken out of context. Coordination measures are already in place to ensure that the Commonwealth states and territories are of one mind on important issues. As a counter-terrorism coordinator, I've witnessed how the ANZ CTC's Legal Issues Working Group is a forum to unpick the complex interactions between federal and state legislation and build strong relationships across jurisdictions. Any changes to existing arrangements would need to be developed in close consultation with states and territories who have significant expertise in the treatment of children in the justice system. We understand that you've reviewed how other countries approach the prosecution and sentencing of children for terrorism offences. The department has regular dialogue with international partners to discuss best practice and share lessons learned. We gain valuable learnings through this dialogue, recognising that policy responses must be suitably adapted to our domestic context. The Monitor's reviews provide an important opportunity to critically review existing national security legislation, ensuring we continue to protect our community in a complex and fluid threat environment. This process bolsters public confidence in Australia's counter-terrorism legislation and is a valuable exercise. The Department of Home Affairs is committed to working constructively with the Monitor. And again, we appreciate the opportunity to be here today. Thank you.
Thank you. Thank you for the invitation to participate in the hearing. The Attorney-General's Department considers the Monitor's role and reviews such as this to be important in ensuring Australia's national security laws effectively protect public safety and safeguard rights and freedoms. Legislation and policy must continue to be flexible and responsive to the evolving threat and in order to allow our criminal justice system to appropriately manage terrorism cases, including those involving children. The current review provides an opportunity to discuss important Commonwealth provisions and how they've worked in practice. Importantly, these provisions need to be viewed in the broader Commonwealth legislative and policy context. They also need to be considered within Australia's federal system, under which states and territories remain largely and appropriately responsible for criminal justice matters, and in particular for management of federal offenders. Mr. Sheehan has already outlined the close working relationship between the Attorney-General's Department and Department of Home Affairs in developing legislative and policy proposals in this area. I also thought it would be useful to make a couple of remarks in relation to the particular sections of the Crimes Act that are being considered. As set out in our submission, the Commonwealth considers that Section 15AA addresses both the rights of an alleged offender and the protection of the community. Terrorism cases in recent years have demonstrated the risks posed by radicalised young offenders. It's therefore appropriate that Section 15AA makes no automatic distinction based on the alleged offender's age. However, a bail authority can still take the age of an offender into account when exercising the discretion that exists under that provision. 19AG similarly allows a sentencing judge to take into account the age of an offender when setting an appropriate penalty. The fixed non-parole period reflects the fact that it would likely take greater time to address the risks posed by the offenders in terrorism cases who have typically been heavily radicalised. In sentencing federal offenders in terrorism cases, courts have made clear that the age or youth of an offender is a relevant consideration, but that this diminishes in certain circumstances, including where a child has committed a crime of violence or considerable gravity. Section 20C1 enables children or young people who are charged with or convicted of federal offences to be dealt with as if the offences were offences against a law of the state or territory. And a key effect of that subsection is that the options available to a sentencing judge may differ based on the state or territory in which the child is being dealt with. More generally, the discretionary nature of sentencing means courts will never achieve absolute equivalence in the sentences handed down. In this area, proposals to achieve greater consistency for prosecution and sentencing of Commonwealth terrorist offenders would require close consultation with and support of states and territories. Thank you again for the opportunity to appear today.
Commissioner.
Here today. The AFP values the independent oversight and recommendations provided by the INSLM through your reviews. Protecting the community from a terrorist attack continues to be the AFP's highest priority. INSLM's reviews are an important mechanism for reviewing and ensuring the ongoing effectiveness of Australia's approach to counter-terrorism in a rapidly changing environment. As we've heard here this morning, since 2014, Australia has seen a significant increase in terrorism offending. We've also seen more young people being involved in terrorist-related activities than in previous years. Amplifying this has been the rapid uptake of social media and encrypted messaging technologies throughout the community, making it easier for young people to connect with individuals they might not otherwise have access to, and also to communicate without close parental supervision. As you outlined earlier, Dr. Renwick, the 2015 Anzac Day plot was planned through hundreds of encrypted messages between a 14-year-old child in the United Kingdom and a 17-year-old in Australia. Social media has proven to be a very powerful tool for extremists to spread propaganda, with sophisticated social media strategies targeted specifically at our youth. We are also aware that some Australian foreign fighters have families in these dangerous conflict zones and may seek to bring their children back to Australia. The presence of children in any counter-terrorism operation creates additional challenges and sensitivities for the AFP in how we manage those. The AFP tailors its approach, taking into account the age and personal circumstances of each individual on a case-by-case basis. This applies regardless of whether the child is a suspect in the investigation or someone who is otherwise impacted by the investigation, for example, a sibling. As far as possible, the AFP supports early intervention activities to divert children and young people going down the path of radicalisation. In November 2014, the AFP established the National Disruption Group, which brought together Commonwealth partner agencies to utilise our capabilities to disrupt offences in support of terrorism investigations. Under the NDG umbrella, the AFP also established the Diversion Operations Team. This team focuses on strategies to develop alternatives to prosecution, such as reintegration and rehabilitation. This focus on prevention aims to ensure vulnerable individuals, including children and young people, are not exploited by extremist and criminal groups and are provided with assistance to select an alternative non-criminal pathway. While the AFP does not run any diversion or intervention programs per se, diversion operations was instrumental in operationalising the Australian Government's Department of Home Affairs Living Safe Together intervention program, and in supporting the states and territories who have responsibility for running their respective programs. Diversion operations assists jurisdictions in identifying, evaluating and assessing at-risk individuals for participation in these state-led intervention programs. As I said, the AFP remains committed to supporting and engaging in prevention or disruption activities that assists in protecting the Australian community from terrorist attacks. Thank you, and I welcome any questions you may have.
Thank you, Deputy Commissioner. Can I start with you, Ms Cook? So you've given us some very useful information about the current threats and the like. Could you expand a little perhaps on how the differences ASIO discerns in how children as opposed to adults become radicalised and how that affects your view of things?
Thank you. In our assessment or our view, there is really a unique pathway that is experienced in respect of radicalisation. It's very difficult, whether child or adult, to really draw a lot of parallels. So one's trajectory through radicalisation through to the movement towards violence is generally quite a unique experience and has unique factors and drivers. That said, there are characteristics of the current and recent environment which have made the radicalisation process much quicker, has accelerated the ability of individuals to acquire and engage with extremist material. And there has been a concerted effort, certainly on the part of ISIL and its use of propaganda and the way that it has communicated its message of intent, which has resonated very strongly. There are characteristics of that which have resonated very strongly with a number of individuals here, including children. In many ways, the use of social media and online platforms and propaganda has been targeted and made attractive to young people, and that's been quite deliberate on the part of ISIL. So encouraging and appealing to young people and reaching out and encouraging and engaging with young people has been part of the strategy of ISIL and the strategy that it's employed. Others will be in a better position to comment on matters of, I guess, the specific vulnerabilities of young people from a psychological or developmental point of view. But certainly in our experience, the transformative time of life for an adolescent or a young person, the types of changes that they're experiencing, the importance of peer groups and belonging and social pressures combined with other sorts of pressures they may be feeling as a young person can be a contributing factor to why belonging to something or the message of the extremist ideology that has been communicated by ISIL, why that has resonated with young people. Belonging to something at a point in time where perhaps a young person doesn't feel they belong where they are, if they're feeling alienated or isolated in their own right, looking for meaning and testing bounds of authority and where they may wish to sort of respect authority and challenge authority. There's a variety of characteristics, I suppose, of that transformative period of adolescence that makes the ideology and the messaging resonate quite strongly. And I think looking at the evidence of young people becoming engaged and moving towards violence and the increase in that number since the rise of ISIL, I think has demonstrated that that strategy has been quite effective for ISIL.
Thank you. Could I ask both you and the Deputy Commissioner a question about the Joint Counter-Terrorism Team? So as I understand them, in each jurisdiction there's a Joint Counter-Terrorism Team typically they're made up of the local police force, the state or territory police force, the AFP, ASIO, and I think I'm right in saying the corrective services authorities from the state or territory now have observer status, is that right?
That is correct, yes.
All right. So we know, of course, that when it comes to formally questioning children, there are special rights of children set out in the Crimes Act and the like. We understand that. But at an earlier stage, that is to say the decision whether to investigate by the JCTT under your respective powers, are there any other particular safeguards that you're able to point to in the case of children? For example, must decisions about whether to commence an investigation be made at a higher level if you're dealing with children? And is there some differentiation between very young children and, if I can call it, later teenagers?
I'll answer in respect of ASIO.
Yes, yes.
And the answer is yes.
Yes.
We do have quite specific internal policies in respect of dealing with children when the need arises. It does involve things, as you suggest, where the authority to interview or seek to interview a young person or a minor requires a higher level of authority to be approved. There are also safeguards in respect of the conduct of an interview of a young person, if that must, if the decision is taken to move forward with that, where assurances around the presence of a parent or guardian or legal representation, as the case may be, is facilitated and arranged. We've certainly don't have any policy against engaging with a child or needing to interview a child. It does not happen very often or with a high degree of regularity, but it's certainly not unique to the current environment. We have long-standing policies and practices that have worked very effectively, and I would have to say we haven't had any difficulty in respect of how that's been managed. But higher authority and certainly making sure there's a presence of a guardian or a parent.
We have very similar processes and systems within the Federal Police. In the joint counterterrorism teams themselves, there's a very strict management oversight and joint management groups that look at specific cases and strategies. We also call on specialist services. So we have psychological support services providing guidance and advice depending on the circumstances of every case, and obviously especially in relation to children or young people, in terms of strategies, how we should be managing and approaching situations where we are considering whether to undertake that investigation.
All right. And the oversight would be, I suppose, the courts in a particular case, the IGIS for ASIO and the Ombudsman for the AFP in particular. Yes, all right.
Yes.
Deputy Commissioner, can I just ask you about alternatives to prosecution? To quote from the joint submission at page 7, it says this: the AFP counter-terrorism diversion team focuses on developing alternatives to prosecution, such as reintegration and rehabilitation, while balancing national security requirements. Now, you've mentioned in your opening some of the different arrangements there. I appreciate the precise numbers might be not something you can share publicly, but can you indicate whether that is frequently done and whether the proportions of diversion as opposed to prosecution are changing?
It's difficult to say because the numbers of children that we have either been in relation, have we either investigated or are peripheral to our investigations is still quite low.
Yes.
So we're always considering the individual circumstances of every case, and at the earliest opportunity, if we can identify that people may be at risk, and there's a number of mechanisms and information that come to us, to our security partners, to state police, to identify some of those factors. It's at those points that we would try to identify, are there strategies where we should either approach the person, their family or others, to see if there is an appropriate diversion strategy that can be implemented quite quickly. It really depends on a case-by-case basis as to at what point we become aware of someone potentially heading down a radicalisation pathway.
Yes, I see. All right, thank you. Mr. Sheen, I had a couple of questions about Home Affairs. You'll be aware, I imagine, that the UK Home Office publishes, I think, every quarter, maybe more less frequently, a publicly available report setting out the number of terrorism offences, arrests, some graphs about sentences and the like. Is there any difficulty in principle with a recommendation from me that we Australia might consider a similar approach, obviously subject to matters of security and the like?
Those matters that are publicly available are regularly made public through ministers' speeches, senior officials' speeches. There isn't, I think, a single place on the Home Affairs website that provides that information, but it is made quite regularly available through public speeches now.
Yes. So what I take from that, Mr. Sheen, is that a recommendation that might be formalised and regularised in that way is unlikely to provoke a particular problem.
Dr. Rennick, I think it would be best I not accept the recommendation, but I would say that a lot of that material is made publicly available, and any recommendation of that nature would be given consideration.
All right, thank you. Ms. Chidgey, was there anything more you wanted to say about 19AG and 15AA? In particular, in relation to 19AG, I think you would have heard in my opening that the submission put against you, if I can put it in that way, is that because it's impermissible for the sentencing judge, at least in theory, to look at the non-parole period when setting the head sentence, and because 19AG admits of no exceptions for adults or children alike, there's a breach of the Convention on the Rights of the Child. Now, is there anything further that you wanted to mention? I know you've dealt with this in your submissions, as to why that might not be a breach.
Thank you. As you've mentioned, our written submissions do detail the relevant safeguards we think exist, which insist ensuring that child offenders are treated in accordance with Australia's international obligations, including those under the Convention on the Rights of the Child and the International Covenant on Civil and Political Rights. And in particular, we would place some weight on the fact that the sentencing court retains discretion about whether to impose a sentence of imprisonment, and if so, what term that head sentence should be, which does allow the child's individual circumstances to be taken into account. But we obviously accept clearly the mandatory nature of the minimum non-parole period places some limitations.
Ms. Chidgey, you mentioned in your opening statement that it's the Department's view that Section 15AA complies with the Convention on the Rights of the Child, in part because the child's age can be taken into account. Is it the Department's view that the age of the child should be a primary consideration for the bail authority?
I think our view is that if it could be done in a way that it still ensured, I think as Dr. Rennick had said, that the protection of the community remains a paramount consideration, that could be acceptable. But we would obviously be concerned to make sure there's no diminishing of the protection of the community by including such a requirement.
I suppose my question was directed at the law as it currently stands. Is the Commonwealth's view that Section 15AA, as currently enacted, allows or requires or permits a bail authority to take into account a child's age as a primary consideration?
Yes, it would allow them to do that.
As a primary consideration, so not just a consideration that could be taken into account, but actually something that could be given primary weight.
They could make that choice to give it primary weight.
And is that something that would be a choice for the judge, or something that they would be required to take into account under the current law?
I think the law doesn't require them to take it into account as a primary consideration specifically.
And I think in the written submissions on behalf of the Commonwealth agencies, the view was taken, I think, that the view is in practice, bail authorities have been making bail decisions that comply with the convention. Is that right?
That's right.
Maybe if I could perhaps add, there have been a number of cases where the age of a young offender has been taken into account in granting bail, which would show the provision working in practice. The only potential difficulty with making it a priority over others if it then outweighed community safety, because obviously that would be the largest consideration in considering a bail for a terrorist offender, the danger that they might pose to society.
And the Commonwealth, of course, is aware that Article 3 of the Convention requires the interest of the child to be a primary consideration. That's the case.
Yes, we're aware.
And so would the Commonwealth expect bail authorities to make decisions consistently with our international obligations?
Yes, we would.
So the current position would therefore be that it is the expectation of the Commonwealth that bail authorities would already, consistently with Article 3, be giving the interests of the child primary consideration. That would be the current law.
Yes, we'd expect that they'd be applying it consistently with international obligations.
So if Dr. Rennick were to recommend that the law be amended to make that expressly clear, that the interests of the child should be given primary consideration, not necessarily paramount, but primary consideration, the view of the Commonwealth would likely be that that merely codifies the current position in fact.
Yes, as long as we've said as that didn't diminish the protection of the community.
Thank you. Can I just ask in relation to parole? So, as I mentioned in the opening, as I understand it, the Attorney-General personally, at least currently, makes decisions about all terrorism parole matters. So another matter for me to keep in mind when making recommendations about 19AG is that, of course, there's no guarantee of parole anymore. That used to be the position. And as we know, I think from media reports recently in relation to a particular juvenile terrorism offender, the attorney refused to grant release, and presumably that person will then have to go to the end of their sentence.
There's a requirement, I think, to reconsider each 12 months.
Yes.
So, yes, so that would come up for consideration again before the end of the sentence.
Yes, indeed. More generally, I mean, given the importance of parole and the role of the attorney, Mr. Bauhaus, you run a fairly small, lean machine when it comes to parole. I think you know that one of the things I'm proposing, considering recommending, is although at present you rely very much on the state and territory parole bodies, it would be useful for the attorney and those acting in his name and people such as yourself to have a legal power on notice to access state and territory prisoners for the purpose of making recommendations about parole. Did you have any view on whether that would be a useful capacity? Might not always be used, of course.
I mean, I should say we get great cooperation from the states and territories, and we rely on them a lot for the information that goes into the parole consideration. So it hasn't been an issue for us to date. We haven't specifically ran into any difficulties with getting access, so that hasn't been a problem to date, but I don't think we have any objection to that as a power per se.
Thank you. This is a question for Ms. Chidgey. You made the comment that Section 19AG allows for a greater time to address the risks posed, given the 3-quarter period. Given that the length of a sentence for a child or young offender who commits a terrorist act is likely to be on the greater side, it's likely that that child or young offender will at some stage move into the adult correctional centre. The New South Wales Department of Justice has provided Dr. Rennick with a submission, which is an unclassified submission it's available on the website, where they note that in the HRMCC, the majority in New South Wales, the majority of terrorist inmates charged with terrorist offences are being held. And they note, and I'll quote from their submissions, There is currently limited capacity for a terrorist inmate to progress from the HRMCC into the mainstream correctional population. The inmates have limited access to services and programs owing to the high-level security needs and the strict association requirements, which do not allow more than 2 inmates to associate at any one time. Given that is the situation in which the terrorist offenders are likely to be held within New South Wales, how can it be said that a greater period in a correctional facility is likely to address the risk posed as opposed to a period on parole in the community where access to de-radicalisation programs is available?
Part of that obviously rests on protection of the community and a person having reached a point at which the risk is sufficiently manageable to enable release. I'll ask my colleague Stephen if he wanted to comment in particular on the New South Wales arrangements.
I mean, perhaps to add, I mean, it is matter primarily for New South Wales about what programs it provides and is able to put in place in prisons, but we would hope that sufficient rehabilitation programs are available in prisons. We understand that generally to be the case, but I'm not really in a position to comment on the specifics of New South Wales. That's really a matter for them about what programs are available, but certainly from the Commonwealth point of view, we would expect programs to be available to rehabilitate prisoners.
The question then is, the de-radicalisation programs are often Commonwealth funded, is that correct? So to what extent is the Commonwealth funding de-radicalised programs within the correctional centres?
I might just answer a little bit of that. So yes, the Commonwealth has contributed funding and works very closely with the states through the ANZ-CTC structures that Mr Sheehan mentioned. And there's been a great focus, particularly in Victoria and New South Wales, of course, on developing those rehabilitation programs, including for young offenders. So we have funded work to bring out international experts to ensure that the best international practice in what is still a relatively new field for this regrettable new cohort that we have of young offenders in particular, to ensure that best approaches are being taken. Those rehabilitation programs are in place. The New South Wales Government in particular has committed significant new resources in its juvenile justice system, and we've been working very closely with them to ensure that there are rehabilitation programs in place targeted at that particular cohort. It would certainly be fair to say, though, that there are no easy answers, and it's certainly not a precise science, and those offenders are being dealt with very much on an individual case-by-case basis to ensure the best chances for rehabilitation in each case.
Does the condition of the grant require the different states and territories to report back to you about the different approaches they're taking?
Yes, it does, and more broadly, even if it weren't required, we have a very close working relationship through the Prisoner Management and Reintegration Working Group, which sits underneath the ANZ-CTC.
And the JCTTs with the involvement now of the corrections, yes.
That's right. So we have a very close working relationship with the states, and we're encouraging all jurisdictions to share their information, including to prepare those jurisdictions that don't presently have any young offenders charged or sentenced, to help prepare them in the regrettable circumstance that they do find themselves suddenly having a cohort of young offenders in their jurisdiction.
All right. Well, can I ask a question perhaps both to Mr Sheen and Ms Chichi about mechanisms for reform of some of these federal issues? I take it from what you've said that about the need for consultation with the states and territories, that whatever I might recommend in relation to 20C and changing the jurisdiction of state courts or territory courts, that would likely go through what, COAG, the ANZ-CTC? Well, what mechanism would you envisage a recommendation along those lines?
Obviously, it would depend, Dr. Rennick, on the recommendation and the government's response to it, but the Legal Issues Working Group that sits under the ANZ-CTC, of which I'm the permanent co-chair, has long been a place to work through those sorts of issues. And indeed, when we had the counter-terrorism COAG last year, we created a task force which was mainly Legal Issues Working Group members to assist us work through a lot of those sorts of issues. So that would be a reasonable starting point, but of course it will depend on what the recommendations are and what the government's initial response to them is.
I mean, is there any major disagreement from either of you about the notion that for a federal offence, some discrepancies in how the state or territory court deal with it, and by that I mean the sentence imposed, might be acceptable in a federation, but very marked differences would be hard to justify, wouldn't they?
We'd accept that principle. So, as you've said, we believe that some variation is part of the federal system and, in fact, sometimes useful in different management options for offenders, but very significant differences, and in particular, say, to maximum sentences available, would potentially be inappropriate.
And Ms Chidgey, you've seen the DPP supplementary submission where the experts in prosecuting have said they're frankly unsure whether particular remedies or powers are available in particular jurisdictions. In principle, there'd be no objection to that being cleared up and made so that people know what the law is.
That's right. It would seem very sound that there should be clarity about the options that are available.
Well, in view of the time, I've only got one more question, and I think it's to you, Mr Sheen. I'm still a little unclear in relation to the COAG decision last year, which, as I understand it, recommended that there be a national approach by states and territories to parole and bail in some circumstances. I can only look at federal laws, whether they're federal surrogate laws or federal laws. I can't myself look at a state law. Is it your expectation that there are going to be state and territory laws which apply to children as well, which apply the exceptional standards requirement for bail? You might want to take that on notice, because if that were so, that might affect my recommendation. In other words, it might be an OTO's recommendation.
Perhaps the best thing is if I give you a short update.
Yes, thank you.
On that, and then from there you can consider what's available to you on an ongoing basis to the inquiry. From what I say, the first thing to say is the Commonwealth Government is committed to implement the COAG agreement to introduce a presumption against bail and parole for persons who've demonstrated support for or who have links to terrorism. The presumption will be implemented in accordance with national principles that were developed in 2017 by the Australian-New Zealand Counter-Terrorism Committee. These national principles, to which all Australian jurisdictions agree, that the presumption against bail and parole should apply to categories of persons who have demonstrated support for or links to terrorist activities. High legal thresholds should be required to overcome the presumption against bail and parole. The implementation of the presumption against bail and parole should draw on and support the effectiveness of the Joint Counter-Terrorism Team, or JCTT, model. Implementing a presumption against bail and parole should appropriately protect sensitive information. And so all jurisdictions agreed under Principle 1 that the presumption against bail and parole should apply to a person who's been convicted of a terrorist offence or is subject to a control order. Additionally, the presumption against parole should also apply to a person who has made statements or carried out activities supporting or advocating support for terrorist acts.
And just pausing there, is that someone convicted of that, or where there's some evidence before the bail authority, for example?
So in the case, if we're talking about parole, then it would relate to statements or carried out activities supporting or advocating support for terrorist acts. In New South Wales, there is additional state legislation, the Terrorist High Risk Offenders Act. I think I've got the name right, THRO, which I think addresses a circumstance where it may not relate specifically to the conviction. You'll see some states have also already introduced legislation consistent with those arrangements, and that's publicly available, obviously,
Yes,
to you.
indeed.
So, if I may suggest it, perhaps the inquiry has a look at what's there, and that'll give you a sense as to what extent that is relevant. None of that would change in principle the way in which provisions apply to children. I'll just double check that with Ms. Chigi.
Yes, that's right. And in relation to exceptional circumstances, the principles that have been agreed don't require that particular mechanism necessarily to institute that presumption, but that is one way of doing it. And for the Commonwealth, for example, in relation to bail, the main change we'd envisage needing to make Commonwealth legislation accord with the principles that have been agreed would be to expand the operation of that provision beyond those who against whom it's alleged that they've committed a terrorist offence to those who also might be being considered for bail for other offences but have supported or made statements in support of terrorism.
All right. Unless there's anything further, in view of the time, may I thank all of you for attending this first session. I should say that I very much value having such senior officers and also for the very detailed submissions you've provided. I'm afraid there will be more questions from me in coming months, but we might pause the broadcast at that moment. We will resume at 11:45 with Dr. Kate Burrell. Thank you very much.